you're a UK landlord and you don't have these 5 things in place this week, you could be looking at a £40,000 fine, or worse, 2 years of rent paid back to your tenants. The Renters' Right Act is now law. It came into force on the 1st of May, and here's what's interesting. Most of the landlords I've spoken to in the last fortnight still don't realise what's exactly changed. So in this video, I'm going to walk you through exactly what's changed, exactly what you need to have in place, and the simple step-by-step plan to make sure you're properly compliant by the weekend. If you're new to the channel, I'm Kaylee, the Yorkshire Property Sourcer. We help busy professionals invest in Yorkshire buy-to-let property completely hands-off. Alongside that, my husband Dale and I run our own portfolio, Flanagan Estates. The same strategy we use for our investor clients, we use ourselves, which means we've spent the last fortnight stress testing our own properties against the new Act property by property. Some of it was already in place, some of it wasn't. And there's a Yorkshire specific angle that nobody else is talking about. I'll come to that towards the end. Here's what's actually changed. Number 1, Section 21 has gone. The no-fault eviction route landlords have relied on for over 30 years is now abolished. From the 1st of May, you can't serve a Section 21 notice if you want a tenant out. You need a specific legal reason under Section 8 and you need to be able to prove it. Number 2, every tenancy is now periodic. Fixed terms have been abolished. Every existing assured short hold tenancy automatically converts into an assured periodic tenancy on the 1st of May. The tenant can give 2 months notice and leave whenever they want. Number 3, rent increases now follow a formal process. Once a year, 2 months notice using a Section 13 form, and the tenant can challenge it in a tribunal if they think it's above the market rate. Number 4, pets. Tenants now have an automatic right to request a pet. You can refuse, but only with a reason the law considers reasonable. Number 5, rent in advance. You can no longer ask for more than 1 month's rent in advance at the start of a new tenancy. If you've been taking 6 months up front from international tenants, that's gone. Number 6, bidding wars are banned. Whatever you advertise the property at, that's the maximum. You can't accept anything above the listed rent price. Number 7, the information sheet. Every landlord with an existing tenant has to serve an official government information sheet by the 31st of May. Miss this, the civil penalty is up to £7,000. That's a lot, so what does it actually mean in practice? Here's the bit most landlords haven't clocked yet. The rent repayment order rules have changed. It used to be if you got something wrong, a tenant or council could claim back 12 months of rent. Bad enough. From the 1st of May, that's doubled. 24 months. 2 years of rent paid back to the tenant. And here's what's interesting. It applies to single-let properties as well as HMOs. It applies to selective licensing failures. It applies to landlords who try to evict on ground 1A, saying they want to sell and then re-let within 12 months. The civil penalty cap has also gone up. It used to be £30,000 per offence. Now it's £40,000. And here's the bit that should genuinely make landlords sit up. There are strict liability offences. If your property needed a licence and you didn't have one, you're guilty. Even if your letting agent was supposed to handle it, even if you didn't know. 2 years of rent on a £1,000 a month property, that's £24,000 per property. So what do you do about it? Right, here's what's on our compliance checklist at Flanagan Estates this week. 5 things every landlord needs done by the weekend. Step 1, serve the information sheet. This is the official government document explaining the changes. Download it from the Gov.uk and serve it on every existing tenant. Every adult tenant individually, not just one per property. Save the email or get a signed copy. Keep the proof by the 31st of May. Step 2, update your tenancy agreement template. Any new tenancy from the 1st of May has to use the new framework. We use it from Nala and they have updated their templates. If your letting agent is still using the old assured short hold template, get them on the phone today. And remember, every existing AST converted automatically on the 1st of May. So even tenancies you signed last year and now periodic, your old paperwork doesn't reflect what's currently in force. Step 3, check whether your property is in a selective licensing area. This is where most landlords trip up. Some councils now require all rental properties to have a council licence, not just HMOs, every single rental. If you're in a designated area and you don't have a licence, you could be hit with the 24-month rent repayment order. I'll come back to the Pacific Yorkshire situation in a moment. Step 4, tighten your tenant referencing. With Section 21 gone, the cost of getting a bad tenant is much higher than it used to be. The court system is already at a 20-year backlog. Median time to repossess a property is 27 weeks before any of these new changes filter through, which means full credit checks, full landlord references, and where you can, speak to previous landlords, not just the current one. Current landlords sometimes give you glowing references just to get rid of a problem tenant. Previous ones have no reason to lie. Step 5, get rent guarantee insurance on every new tenancy. With the eviction process realistically stretching towards 12 months on contested cases, the maths on rent guarantee insurance has changed. The annual premium used to be a nice to have. Now it's the difference between protecting your investment and losing 5 figures of the rent. Those 5 things: information sheet, updated tenancy template, licensing check, tightened referencing, rent guarantee insurance, get those done by Sunday and you're properly compliant. Now here's the bit I genuinely haven't seen anyone else cover properly. If you invest in Yorkshire like we do, the selective licensing picture is dramatically different from the rest of England. Leeds, the biggest city in the country, has just rolled out a major selective licensing scheme that came into force in February. Parts of the Inner East, South and West Leeds, Beeston, Hare Hills, Armley, Hunsler, around 12,500 rental properties now need a licence. Application fee £1,100, penalty for non-compliance up to £30,000, plus the 24-month rent repayment order on top. But, and this is the bit that matters, Wakefield Council has explicitly ruled out selective licensing. They've said publicly they don't meet the government's criteria, which means Pontefract, Castleford, Featherstone, Nottingley, Normanton, Hemsworth, the entire 5 towns area currently has no selective licensing requirement. Selby is the same picture. North Yorkshire Council has selective licensing in 2 specific Scarborough wards only. Selby and York have no selective licensing. Goole sits in East Riding of Yorkshire, and East Riding has no selective licensing scheme at all. So a landlord with 1 property in Beeston, Leeds, is now staring at an £1,100 fee, ongoing inspections, and a £30,000 risk if they get it wrong. A landlord with the same property in Pontefract pays nothing, has 0 new licensee exposure, gets the same Yorkshire yields. That's not a small difference, that's the difference between a stressed landlord and a calm one. The towns we focus on at YPS, Pontefract, Castleford, Selby, Goole and York, are some of the lowest risk locations in the entire country for selective licensing exposure right now. That doesn't make us complacent. Things change. We're checking the council position quarterly and we'll keep our investors informed. But for now, Yorkshire, outside Leeds and Scarborough, is genuinely one of the safest places to be a landlord under the new Act. So that's the position. Renters' Right Act is live. 5 things on your to-do list this week: information sheet, tenancy template, licensing check, tighter referencing, rent guarantee insurance. Do those and you're sorted. The landlords who get caught out by this act won't be the professional ones. They'll be the accidental landlords. the ones who inherited a property, the ones who tried to sell but couldn't and ended up letting it out without realising what's changed. This isn't for everyone, by the way. If you've got the time to manage all of this yourself, brilliant, go for it. But if you're a busy professional and you'd rather someone else handle the paperwork, the licensing checks, the referencing, the rent guarantee, that's exactly what we do here at YPS. By the way, if you'd like to talk through what hands-off Yorkshire property could look like for your situation, drop Yorkshire in the comments and I'll send you a link to book a free discovery call. Worst case, you walk away with absolute clarity on whether this is right for you. Best case, we go and find you your first deal together. This is Kaylee, the Yorkshire Property Sourcer, helping you invest in property the right way. I'll see you in the next video.